Hi, friends. Hi, neighbors. It's Emily. I hope you are having a great week before Christmas. I can't even fathom that next week is Christmas. This year has both seemed a blur, and I feel like Christmas was yesterday in a lot of ways. Last Christmas was yesterday in a lot of ways. I have coffee to drink today. It's still like 9-ish here. Um, we'll see. Um, Today, I wanted to talk about this new Second Amendment to the complaint filed against select members of Fairfield Harbour and our board property owners association and select members of our current and former board. And so I am going to read through that. I don't know if you guys have ever seen, but on YouTube, there is this, what's the name of this channel? It's called Sleep and History. And they have like all these, they're like 2-ish hours to help you fall asleep. The guy that narrates it, his voice is super soothing and calm. They have videos like what Victorian servants actually did all day. It's 2.5 hours. Strange medieval food habits that still exist today. I listen to this all the time when I can't go to sleep. And that's the intent in which I am doing this podcast. The new second amended complaint is about 125 pages. 49 of those are the actual complaint itself. And then the back half of that document, the remaining 75-ish pages, are all exhibits. I think there are 9 now. So we'll kind of leaf through those. In my last podcast, we went through the first few, but I think there's been a couple added. So feel free, if listening now is not your jam, but you want to come back and be able to listen to this, I'm just going to read it to you for those that don't have the time in this busy holiday season or the ability to read this complaint. I pulled this link off of it was posted on one of our Facebook channels. I can't keep up with which one, but as we all know, I'm blind. My hair is just as frizzy as all the nerves left in my body. So we are going to read through this, okay? Here are the select members of our community that have, again, backed this lawsuit with their financial dollars, put their money where their mouth is. And again, this is the Second Amendment amended complaint. And I do appreciate all the blue in here and whoever uploaded this, making sure that we could see what was changed. So helpful. And then you will see under these are the plaintiffs. And then you will also see under the defendants, we have added Don Moore, Michael Foster, and Lee Fawcett in their capacities as officers and directors of our Fairfield Harbour Property Owners Association. Now come all plaintiffs, both individually, directly, and derivatively, as owners of property and members of Fairfield Harbour Property Owners Association, Inc., by and through undersigned counsel, and complaining of defendants, and hereby allege and say the following. Introduction. And I am not going to read where we have cross throughs. I'm not going to read those. I am just going to read this as if you in Microsoft Word selected show final version of the document so that you don't see all of the markups. That is the way in which I'm going to read the Second Amendment complaint. For those that are watching, hi, I'm so glad that you're here. Feel free to not listen. I'm hoping that this is something that folks can listen to in the car, at the grocery store. But if you have nothing else to do, grab a glass of whatever you're drinking, coffee, and we're going to get into it. So in this introduction, this action arises from the unlawful and defensive actions of the Board of Directors of Fairfield Harbour Property Owners Association, Inc., further known as the Association and/or Defendant Association. The Fairfield Harbour subdivision is a 2,800 plus lot planned community in Craven County, North Carolina. In spring 2024, a majority of the eligible property owning members of Fairfield Harbour Property Owners Association successfully voted to remove 2 members of the board of directors. On June 28, 2024, in an unveiled effort to protect themselves from meeting the same fate, a majority of the remaining directors of the board unlawfully purported to hold a vote amongst themselves to change the association's bylaws. Specifically, the board voted to require a supermajority vote of 67% of eligible members to remove a director, when the existing requirement for removal was a majority of the members who voted. This action not only violated the express language of the association's bylaws, it was also a clear and unabashed violation of North Carolina General Statute Section 55A-8-08, which limits and caps the votes required to remove a director to that which would be sufficient to elect the director at a meeting of elected directors. Did I say that right? Would be sufficient to elect the director at a meeting to elect directors. Even if an increase of the vote required for director removal was permissible under the bylaws or applicable law, such an amendment could have only been approved by an affirmative vote of the association members under North Carolina General Statute Section 55A-7-23 voting requirements and 47F-3-103B executive board members and officers. Further, the purported amendment of the bylaws must have been attempted either through North Carolina General Statute Section 55A-10-20 amendment by directors or North Carolina General Statute Section 55A-10-21 amendment by directors and members. If North Carolina General Statute Section 55A-10-20 was the statute purportedly employed, the amendment fails due to lack of compliance with the notice requirements and failure to recognize that the corporation has members entitled to vote thereon. If North Carolina General Statute Section 55A-10-21 was the statute purportedly employed, the amendment fails because members were not involved in the purported amendment process. Lastly, even if the board had possessed authority to amend the bylaws to require a supermajority vote for director removal, their action was invalid due to a lack of proper notice of the vote, which was not waived. In September of 2024, another member's vote was taken to remove 4 directors or any of their replacements for the remaining portions of any term without cause, the results of which were a majority in favor of removal, but which the board of directors deemed a failure due to the lack of a supermajority vote. Accordingly, plaintiffs now seek inter alia declaratory relief, affirming that the aforementioned vote 52.31%, to remove the 4 directors was valid and effectual. The conduct of the board of directors in amending the bylaws was ultra vires and void ab initio, and declaring that the voting requirements for removal of a director must comport with all provisions of North Carolina General Statute Section 55A, including but not limited to 55A-8-08C. Plaintiffs further seek to enjoin the board of directors from taking any action based upon their purportedly amended bylaw requiring a supermajority vote to remove a director, and to enjoin the 4 removed directors or their replacements from taking any action as directors. Plaintiffs seek removal of the 4 directors and their replacements that were voted against in September 2024 and to reinstate the bylaws as they existed prior to the board's unlawful vote of June 28, 2024. Again, in blue, this is what is being added. In addition, the second amended complaint is partly derivative in nature and includes additional defendants and claims to include more recent board members who are aware of the unlawfulness of the current bylaws, but who refuse to act in breach of their fiduciary and contractual duties to bring the bylaws into compliance with law and the governing documents, and their ongoing disregard for the lawful and unlawful actions. Most recently, on December 3rd, 2025, the Board of Directors purportedly amended the bylaw at issue, a clear acknowledgement that the plaintiff's litigation of same is well-founded and meritorious. However, defendants' most recent amendment constituted yet another unlawful board action. The purported amendment does not revert the bylaws to its original lawful majority standard. Rather, it still requires a 67% vote for removal, although it is now for 67% of votes cast, reduced from even more unattainable threshold of all eligible votes. The material breach of fiduciary and contractual duties by all defendants extends to all plaintiffs and the association because defendants have created a fiduciary relationship based upon their explicit assertions, including legal advice that the association's members lacked the right to vote and defendants' active refusal to recognize a passing member vote to remove directors. So now that was our introduction, okay? So we kind of laid out what we're going to talk about here. Parties, jurisdiction, and venue. Okay, so this is more of just the mechanics of how this is going to operate. The Fairfield Harbour subdivision, as shown on maps recorded within the Craven County Register of Deeds, incorporated herein by reference, is a planned community with over 2,800 lots in Craven County. At all times, material hereto, plaintiffs owned and continue to own real property within the Fairfield Harbour subdivision as listed below. The membership of the association is more than 50% senior citizens, many of whom are on a fixed income, and it is the financial impact of the board's decisions that have driven the actions of the memberships discussed herein and below. All plaintiffs herein bring this action individually and directly, as well as derivatively on behalf of the association as members, owners of property within Fairfield Harbour Property Owners Association, Inc. Plaintiff. Then we go through. This is multiple pages of the person, the fact that they are a resident of Craven County, and what their property address is. I am not going to read through these, but you will see all of the plaintiffs listed here. We get to number 37 after we talk about Robert Jankowski. As owners of real property within Fairfield Harbour subdivision, all plaintiffs were and are members of Fairfield Harbour Property Owners Association, Inc., as of now, and as of the date of the unlawful acts complained of herein, including but not limited to the contractual breach and the unlawful, improper, and ultra vires amendment to the association's bylaw by vote of the Board of Directors of the association as further described below, which the current Board of Directors refuses to correct to date. The Master Declarations of Fairfield Harbour, dated October 23rd, 1979, sets forth certain provisions applicable to properties in the Fairfield Harbour subdivision and declares that property owners shall become members of Fairfield Harbour Property Owners Association. See Master Declarations of Fairfield Harbour, that's Exhibit 1, page 7. That's the first exhibit at the end of this. It starts on page 50. The Master Declaration of Fairfield Harbour describes the Fairfield Harbour subdivision in part as certain properties in number 2 Township, Craven County, North Carolina, a portion of which properties were conveyed to Fairfield Harbour, Inc. by deed from Treasure Lake of North Carolina, Inc., dated December 9th, 1977, and recorded in Book 901 at page 504 in the office of the Register of Deeds of Craven County, and a portion of the aforesaid properties together with certain properties adjacent or contiguous 2 or in the general vicinity thereof comprised a development known as Fairfield Harbour. See Master Declarations. Again, this is Exhibit 1, page 1. Also, articles of amendment to the restated Charter of Fairfield Harbour Property Owners Association filed August 12th, 1983 describes the Fairfield Harbour development as the same may now or hereafter be shown on the maps and deeds thereof, recorded from time to time, including without limitation the property shown on the maps of Treasure Cove subdivision. That property identified in those deeds recorded in Book 901 at page 504, Book 930 at page 798, and Book 964 at page 936 of the Craven County Registry, and all that property contiguous to or in the general vicinity of the foregoing property. And that's Exhibit 2. You can read in full. Defendants. The defendant, Fairfield Harbour Property Owners Association, a nonprofit corporation organized under the laws of the state of North Carolina, is the Property Owners Association, which is charged with the management of the development known as Fairfield Harbour, located in Craven County, North Carolina. This is Exhibit 3, Declaration of Unit Ownership, page 1. Defendant, Fairfield Harbour Property Owners Association, Inc., hereinafter referred to as the association, is a nonprofit corporation incorporated and existing under the laws of the state of North Carolina, with its principal place of business and principal business office being located in Craven County, North Carolina. Defendant, and then we talk about who the defendants are in name, right? So outside of the association, it is Les Pendleton, Robert Brody, Larry Baston, Susie or Debbie Harris, and Donald Moore, which we added, Michael Foster, Lee Fawcett, and it says the individual defendants are sued in their capacity as officers and members of the board of directors of Defendant Association. This court has jurisdiction over the subject matter of this action as well as over parties hereto. The venue is proper in Superior Court of Craven County, North Carolina. Now, here we get into the statement of facts. This is where we are given the details, okay? At the time of the actions complained of herein, the association was governed by the 2020 amended and restated bylaws of the Fairfield Harbour Property Owners Association, Inc. See bylaws, that's Exhibit 4, and that is attached for your pleasure. The bylaws of the association called for a 7-member board of directors, each of whom were to be elected by a plurality vote of members at the annual meeting. Before and in 2024, the above captioned plaintiffs and other members of the association held grave concerns about certain actions and financial decisions by the board of directors of the association. A significant concern related to the defendant's investigation of a multi-million-dollar construction project for the construction of a clubhouse, the Harbor Club, hereinafter referred to as the Clubhouse Construction Project or Construction Project. The concern related to a belief amongst many members that a membership vote to determine whether the association should proceed with this construction project was needed and or required, as many were not in favor of this expensive project for various reasons. These concerns prompted a petition for a member vote of the two. Let's start again. These concerns prompted a petition for a member vote for the removal of 2 members of the board of directors. On or about May 13th, 2024, the results were announced, that being that the majority of the association members were in favor of removal of the 2 directors. In a heavy-handed and unlawful reaction to this member vote, the remaining members of the board of directors attempted to avoid a similar fate, which is one basis of this instant litigation. On June 28, 2024, the board of directors held a meeting. The minutes of this meeting are Exhibit 5. At no time prior to this meeting was notice that a motion to amend the bylaws would be made, and this item was not listed on the meeting's agenda, which is a requirement of our bylaws. Notably, there was an hours-long public meeting for all owners just 2 days earlier, and this unlawful proposed bylaw amendment was not disclosed to the members then or at any other time. However, after the meeting began and after new officers were elected, board member defendant Les Pendleton, and here's a quote from the meeting minutes, asked if it would be possible to amend the bylaws so that a petition for removal of board members would have to have a cause and a supermajority. Director Pendleton made a motion to add a bylaw change to the end of the agenda, seconded by Vice President Pfefferkorn, approved by President Albertini, Vice President Peppercorn, Directors Brody, McLam, and Pendleton. Opposed were Directors Barajas and Moore. The motion passed by a majority vote. Director Pendleton made a motion to amend the bylaws stating that any vote for a removal of any member of the Fairfield Harbour POA Board, including current members, will require 67% of POA members who are eligible to vote according to the POA bylaws in effect at the time of said recall ballot is distributed for voting. President Albertini made a second, and it was approved by President Albertini, Vice President Peppercorn, Directors Brody, McLam, and Pendleton, and opposed were Directors Barajas and Moore. Motion was approved by a majority vote. Attorney Carmichael will send a letter to Secretary Miller with the exact wording needed for the amendment. And that's in Exhibit 5, pages 2 and 5. And then the resolution 2024-03 of the Board of Directors of Fairfield Harbour Property Owners Association, Inc. was later entered stating as follows. A vote for removal of a director may be called by the Board of Directors or by petition of the members for special meeting as otherwise provided in these bylaws, provided, however, that the vote required for removal of a sitting director who has been duly elected or appointed pursuant to these bylaws shall not be less than 67% of the eligible vote of the POA membership. This is Resolution 2024-03. That's Exhibit 6 attached. The actions set forth above were unauthorized, unlawful, and invalid. Not only did this purported bylaw change at Article 5, Section 9 by the Board of Directors violate the wording of the bylaws themselves, North Carolina General Statute Section 55A-8-08, and other sections of Chapter 55A and or Chapter 47F, it was effectuated without proper notice, which was not waived. Even if such a change to the bylaws, the purpose of which was to increase or decrease the vote required for any member action, was authorized by law, only the association's members could have voted for and approved such a change. In or around August 2024, some plaintiffs herein submitted a petition for a special meeting of the purpose. In and around August 2024, some plaintiffs herein submitted a petition for a special meeting for the purpose of removing 4 of then current directors, Les Pendleton, Gail Albertini, Robert Brody, David Pfefferkorn, or any of their replacements for the remaining portions of any term without cause. On September 27, 2024, the results of the ballot for such approval were as follows. For removal of the 4 members of the Board of Directors, 52.31%. Against the removal of the 4 members of the Board of Directors, 47.69%. That is Exhibit 7. Under the purported unlawful bylaw amendment requiring a 67% supermajority vote, the Board of Directors then declared that the recall measure to remove the directors failed. Plaintiffs have been harmed by the board's declaration that the measure failed and by allowing the directors and or their replacements whom a majority of members voted to remove remain on the board and continue to make decisions affecting all parties to date. Moreover, plaintiffs and the association continue to be harmed by ongoing existence of this bylaw, which effectively removes the protection afforded them, to wit, the ability to remove any director by a majority of votes cast, an essential right. In making this purported amendment and then refusing to fully correct it upon receiving notice that it was and is unlawful, defendants violated their own bylaws and multiple North Carolina general statutes. The board's actions violated the express terms of its bylaws and the North Carolina Corporation Act. In Article 4, official meetings of members, at Section 6 of the association bylaws, it is specified that association members elect the board's directors through a plurality vote. Quote, with the exception of the DOR amendment, 67% affirmative, and the election of directors of the FHPOA plurality vote, any meeting of the members of the association at which a quorum is present, or any vote by mail-in ballot without a meeting where a quorum has participated, the vote of a majority of those votes cast shall be necessary for the adoption of any matter voted upon by the members. This is in Exhibit 4, page 6. Article 5, removal of directions. At Section 9 of the association bylaws, it is specified that the removal of directors is governed by North Carolina General Statute Section 55A-8-08. Did that flip? Okay. Pursuant to North Carolina General Statute 55A-8-08 and Article 4, Section 4B of these bylaws, directors may be removed from office with or without cause at a special meeting of the members of the association called specifically for such a purpose. Section 55A-8-08, the North Carolina Nonprofit Corporation Act, removal of directors elected by members or directors, states, without allowance of the bylaws or other governing documents to specify otherwise, the members may remove one or more directors elected by them with or without cause unless the articles of incorporation provide that directors may be removed only for cause. If a director is elected by a class, chapter, or other organizational unit, or by region or other geographic grouping, the director may be removed only by that class, chapter, unit, or grouping, except as provided in subsection I of this section. A director may be removed under subsection A or B of this section only if the number of votes cast to remove the director would be sufficient to elect the director at a meeting to elect directors. In addition, North Carolina General Statute Section 55A-7-23 voting requirements states unless this chapter, the articles of incorporation or the bylaws require greater votes or voting by class, if a quorum is present, the affirmative vote of a majority of the votes cast is the act of the members. An amendment to the articles of incorporation or bylaws on which members are entitled to vote, the purpose of which is to increase or decrease the vote required for any member action, shall be approved by the members entitled to vote on that action by a vote that would be sufficient to take action before the amendment. Thus, because the voting requirement for removal of a director is specifically governed by Section 55A-8-08, a fact that is also specifically acknowledged in the bylaws themselves, the voting requirement set forth within 55A-8-08C cannot be changed. The North Carolina commentary to Section 55A-8-08 states that subdivision K1 was limited to charitable or religious corporations in order not to give other nonprofit corporations in which members may have property rights full power to limit the application of this section in general. In other words, the commentary confirms that property owners have a substantial interest in maintaining the ability to remove a director if needed, and that there was nothing optional about the requirements within. Alternatively, if this court finds that such an amendment to increase the vote required for director removal was permissible by contract, the bylaws, or statute, which is not believed to be possible per the above, then plaintiffs assert that such amendment could only be effectuated by a vote of the members under Section 55A-7-23B. Defendant's response to that Article 9 of its bylaws as they existed at the time of the vote allowed Board of Directors the unfettered right to amend any and all bylaws fails as inconsistent with the bylaws themselves, see Article 5, Section 9, removal of directors, the applicable North Carolina general statutes cited above and below, and laws of contract interpretation. The North Carolina General Statute Section 55A-2-06 bylaws states that the bylaws of a corporation may contain any provision for regulating and managing the affairs of the corporation that is not inconsistent with the law or the articles of incorporation. At the time of the Board of Directors' unlawful amendment of the bylaws, Article 9 of the bylaws stated in its entirety, these bylaws may be amended by the affirmative vote of 5 of the 7 board directors of the board. Article 9 is specifically limited by Section 55A-8-08, removal of directors elected by members or directors, which 1 does not contain a clause allowing an exception to this applicability, as it does, for instance, with respect to limiting removal of a director for cause only in the Articles of Incorporation so provide, and 2 expressly states that a director may be removed under subsection A or B if this section only if the numbers of votes cast to remove the director would be sufficient to elect the director at a meeting to elect directors. Thus, the purported amendment was inconsistent with law, including North Carolina General Statute Section 55A-8-08. By way of further explanation, any amendment to the bylaws must be consistent with Section 55A-8-08C, which states a condition of a director removal must be that the number of votes cast to remove the director would be sufficient to elect the director at a meeting to elect directors. As per the bylaws, the number of votes sufficient to elect a director is a plurality. Therefore, the number of votes necessary to remove a director cannot be less than a plurality. The 67% provision purportedly adopted by the board violates this provision. The number of votes sufficient to elect a director by plurality is a majority only at most. For example, if 2 candidates were running and there were 100 eligible votes, then the number of votes sufficient to ensure a win for any particular candidate is 51, which is a majority. If 3 candidates were running and the number of votes sufficient to ensure a win for a particular candidate is 34 of 100. Under the same scenario, if 4 candidates were running, then the votes needed to ensure a win is 26. In sum, the number of votes sufficient to be elected as a director is at most a majority. Therefore, the attempt by the Board of Directors to change this requirement to 67% supermajority violates North Carolina General Statute Section 55A-8-08C and the bylaws. Alternatively, if the bylaws could in fact be amended to contravene Section 55A-8-08, which is denied, it is submitted that such amendment could only be effectuated by successful vote of the members pursuant to North Carolina General Statute Sections 55A-7-23 voting requirements and 55A-10-21 amendment by directors and members. By virtue of being owners in the subdivision, each owner is a member. The corporation has members. The members are entitled to vote on amendments to bylaws. The bylaws purport to allow the directors to amend the bylaws, but do not preclude amendment of the bylaws by the members and expressly allow members to vote on matters. Members are entitled to vote on amendment to the bylaws, which is to increase or decrease the vote required for any member action, and the vote by members that was sufficient to amend the bylaws prior to the amendment in question in this case was majority. The board's actions also violated the Planned Community Act as made applicable through its master declarations and bylaws. Plaintiffs further assert that the defendant association was submitted to the provisions of the Unit Ownership Act or to any similar act providing for condominium or unit ownership of property, which includes a Planned Community Act, North Carolina General Statute, Section 47F, which mandates that removal of directors can be accomplished through a majority vote of members. North Carolina General Statute 47F-3-103B, Executive Board members and officers. The Master Declaration of Fairfield Harbour states, for each property subject to the provisions of this Master Declaration, the provisions to which such property is subjected shall be applicable to each subdivided lot therein, each unit in a tract of land submitted to the provisions of Unit Ownership Act under 47A of the North Carolina General Statutes, or to any similar act providing for condominium or unit ownership of a property. That's in Exhibit 1 at page 2 in the Master Declarations. Owners Association, Inc. states in relevant part, every person upon acquiring title, legal or equitable, to any property in Fairfield Harbour subjected to the provisions hereof shall become a member of the Fairfield Harbour Property Owners Association, Inc., a North Carolina nonprofit corporation, hereinafter referred to as the Association. Article 10 of the Master Declaration, Grantee's Acceptance, states in relevant part, the grantee of any property subject to the provision hereof by acceptance of a deed conveying title shall accept such deed or contract upon any subject to each and every provision hereof applicable to such property and the agreements herein contained, and to keep, observe, comply, and perform with such provisions. That's Exhibit 1, page 19. The bylaws adopt and invoke North Carolina General Statute, Section 47F, no less than 6 times within the document. Powers, the board shall exercise the enumerated powers in North Carolina General Statute 47F and 55A. Perform any and all other acts for which the authority has been granted herein or under North Carolina General Statute 47F and or 55A. Pursuant to North Carolina General Statute 47F-3-108B, the board shall, at regular intervals, hold a board meeting. If any uniform annual assessment or levied assessment is not paid when due, it shall bear delinquency charges established by the board in accordance with North Carolina General Statute 47F. And the association may place a lien on any lot or unit, or take any such other action prescribed in accordance with North Carolina General Statute 47F to collect any unpaid delinquency, charge, or assessment. The association shall indemnify and maintain liability insurance for its officers, directors, employees, and agents consistent with provisions of the North Carolina Planned Community Act, North Carolina General Statute 47F, Exhibit 4, that's pages 9, 11, 13, 17, and 19. North Carolina General Statute 47F-3-103, Executive Board members and officers states in part, notwithstanding any provision of the declaration or bylaws to the contrary, the lot owners, by a majority vote of all persons present and entitled to vote at any meeting of the lot owners at which a quorum is present, may remove any member of the executive board with or without cause other than a member appointed by declarant. The charter and bylaws of an association constitute a contract between the organization and its members when the members are deemed to have consented to the reasonable regulations and rules of the organization. Traditional rules of contract interpretation apply when assessing whether the association followed its own internal rules and procedure. Master versus Country Club of Landfall gives another case that is referenced here. Because bylaws of a voluntary association are treated as a contract between the entity and its members, see the Master 263 NC App at 187, the court must enforce the unambiguous term of the bylaws as written. If the contract is clearly expressed, it must be enforced as it is written. It gives another case to cite. It is central principle of a contract interpretation that the various terms of a contract are to be harmoniously construed so that every provision is given effect if possible. Bylaw drafters can choose to restrict some powers of the board while leaving others unfettered. Observing this distinction allows a harmonious reading of the bylaws as a whole that better effectuates the intent of the drafters. Thus, the express invocation of the Unit Ownership Act is the Master Declaration, along with the plain and express language of the bylaws, the latter of which repeatedly reference Section 47F generally and without limitation, brought Section 47F and its removal requirements under 47F-3-103 squarely into the association's bylaws and procedures as a matter of basic contract interpretation. The association may not incorporate in its governing documents and utilize North Carolina General Statute Section 47F in practice, which is a similar act regarding unit ownership of property, and then later argue that it is not bound by the provisions of North Carolina General Statute Section 47F. The association is estopped from taking such inconsistent and self-preserving positions. C. The board's action was invalid due to lack of proper notice. Even assuming arguendo that the board of directors did not have authority to amend the bylaws to increase the vote required to remove a director, they failed to validly take such action on June 28, 2024 due to lack of proper notice and lack of waiver of proper notice. Resolution 2024-03 states that the amendment of the bylaws by the board of directors was effectuated pursuant to Article 9 of the bylaws. Counsel for defendants, in response to the derivative demand letter by counsel for plaintiffs Wesley Collins, asserted that the lack of notice was waived pursuant to North Carolina General Statute Section 55A-8-23. Counsel for the defendants wrote, "The association does not dispute that the amendment in question was raised by motion at the board's June 28, 2024 meeting. The failure to provide notice of the potential amendment does not, however, invalidate the amendment. A, directors' attendance at or participation in a meeting waives any required notice of the meeting unless the director at the beginning of the meeting or promptly upon his arrival objects to holding the meeting or transacting business at the meeting and does not thereafter vote for or assent to action taken at the meeting." And I'm not going to interrupt this. I'm trying to read it completely through, but I will say I did a whole nother podcast episode when this happened, that directors attending the meeting being their waiver of notice that the meeting was happening and that any business was going to be transacted at the meeting, they cannot assent to or preclude, say, I object to any of this business happening if they don't know what business is happening because it's not on the agenda at the beginning of the meeting. As stated above, and as admitted by counsel for defendants, 5 days written notice was not given under Section 55A-10-20 and 21. The meeting's agenda did not include this amendment to the bylaws. Thus, the objecting directors could not object to holding the meeting or transacting business at the beginning of the meeting, as nothing objectionable had occurred until the meeting was underway. Case in point. Moreover, the meeting minutes state that 2 directors opposed the motion to add the bylaw change to the end of the agenda. The 2 directors then persisted in their objection by voting against the amendment. In other words, they did not thereafter vote for or assent to the amendment. North Carolina General Statute 55A-8-23B. Due to the Board of Directors' failures to follow proper procedures and to give legally sufficient notice concerning the proposed vote and amendment of the bylaws, the directors' vote and purported amendment was improper and/or are ultra vires acts of the association and are void ab initio. Plaintiffs supplied notice and made demand under Section 55A-7-40, which was refused, and even after months of litigation to include receipt of expert opinions that the board's action was unlawful, and all defendants persist in refusing to restore the bylaws to the lawful compliance in breach of fiduciary and other duties. Here we are adding a whole nother section. On May 3rd, 2024 and October 9th, 2024, plaintiffs made demand upon defendants for the actions desired set forth above and below via letter, in which it was requested that said letter be shown to all board members. See North Carolina General Statute 55A-7-40. On October 18th, 2024, defendants refused the demand through their counsel. In early 2025, plaintiffs filed their complaint/amended complaint in the Superior Court. All defendants were served and on notice of the detailed claims. In addition, there has been an election and some of the members of the Board of Directors have changed. The newly added defendants have been members of the Board of Directors for many months, during which time they have had notice of the unlawfulness of the amended bylaw, as well as plaintiffs' ongoing demand and request that the bylaw be changed to what it was in 2020, returned to the lawful requirement that only a majority is required for removal. The newly added defendants, as well as other defendants, have also received further written notice through the disclosure of the expert report of Thomas Judson, that's Exhibit 9, and we'll read through that, which provided even further detail and information regarding the unlawfulness of the bylaw as amended and how it currently exists. All defendants are on clear, repeated notice that their refusal to correct the unlawful bylaw is improper, unlawful, and/or ultra vires, yet they have purposefully refused to correct it. The clear, detailed, and precise explanation to all defendants of the illegalities of the bylaw amendment as set forth above, including in the derivative demand letter, complaint, amended complaints, expert report, publicly filed pleadings, renders their ongoing refusal to act by all defendants to correct it unwarranted, unreasonable, and completely unprotected by the business judgment rule and/or other statute governing directors and officers' standards and conduct, to include those set forth in North Carolina General Statute Section 55A-8-30. It was made plain to all defendants that the bylaws, as it now exists, benefits the sitting directors by practically and effectively protecting them from removal, regardless of any malfeasance, crime, or other reasons, due to the unattainable requirement of a 67% vote, effectively entrenching them in office, to the great harm and detriment of the association and its members. Further proving that the current Board of Directors has knowledge that the bylaws are unlawful, and by not adhering to the majority vote cast requirement on December 3rd, 2025, said Board of Directors, specifically defendants Moore, Foster, Brody, Baisden, and Fawcett, amended said bylaw by Resolution 2025-09, which reduced the vote needed from 67% of all eligible votes to 67% of votes cast. See Exhibit 10, Resolution 2025-9. with statement from Board of Directors. In purportedly amending the bylaw again, yet maintaining its illegality through its unlawful high threshold, defendants misled the membership about the facts that the bylaws would remain unlawful while improperly publicizing and distorting the events of a confidential mediation and portraying plaintiffs in a litigious while concealing. Did I read that right? Purposefully misguiding the membership owners plaintiffs about their right to vote on this construction project. Oh, I'm sorry. Wait. Something's happening with my buttons. In purportedly amending the bylaws again, yet maintaining its illegality through its unlawfully high threshold, defendants misled the membership about the fact that the bylaws remain unlawful while improperly publicizing and distorting the events of a confidential mediation and portraying plaintiffs as litigious while concealing that the bylaw was amended in 2024 and, as amended in 2025, is illegal and in violation of the law. Defendants are pretending to be peacemakers by partially walking back the egregious terms of the removal bylaw while attempting to portray plaintiffs in a poor light through their false narrative. This willfully deceptive conduct justifies punitive damages. Defendants breached their fiduciary duties by voting themselves upon the clubhouse construction project, immediately followed by the unlawful bylaw amendment in a self-serving decision that was unwarranted, unreasonable, and not in good faith. As stated above, plaintiffs and other owners had concerns related to the multi-million-dollar clubhouse construction project for the Harbor Club. Members vocalized to defendants the desire for a membership vote to demonstrate whether the majority of owners/members desired to go forward with the construction project. However, on June 26, 2024, and on other dates, defendants responded and asserted that the members legally had no right to vote on this construction project. This was plainly wrong and purposefully misleading. Defendants acted in concert and purposefully stated this assertion at times using the board's attorneys to convey this information to avoid the expense of a membership vote and in order to move forward with the construction project simply because the defendants were personally in favor of it. By purposefully misguiding the members, owners, plaintiffs about their right to vote on the construction project, utilizing their attorney to support their unlawful act and generate the appearance of authority in spite of the language in the bylaws that demand a membership vote on this extremely costly capital expenditure, defendants created a de facto fiduciary relationship in which they violated by acting in their own interest and not in the best interest of the association as set forth more fully below. Therefore, to entrench themselves in their positions and thwart members' ability to remove them after they illegally vote on the clubhouse construction project, defendants then purposely amend the bylaws as stated above in the very same June 28, 2024 meeting. Notably, defendants held a public meeting just 2 days earlier on June 26, 2024, at which the proposed amendment to the bylaws was never raised, and during which time defendants purposely evaded the question put to them about whether the clubhouse construction project would be put to a membership vote. This concealment of the proposed bylaw amendment and its prompt effectuation without notice to others, coupled with the immediate board vote to approve the clubhouse construction project just days after the public meeting, demonstrated the bad faith scheme and designed to disenfranchise members and was a continuation of the false narrative that members were not entitled to vote on the clubhouse construction project. Now, nearly a year since the complaint was filed, all defendants have refused to correct the bylaws to comply with inter alia section 55A-8-08, and because this unlawful bylaw only serves to benefit directors by entrenching them in office, while causing ongoing harm to members who have no meaningful vote, which harms the association itself by creating an entrenched board that can act however it wishes, the decision not to reform, revert, correct the bylaw to the statutorily required parameters example, majority vote for the removal, is unreasonable and not protected by any business judgment rule. Because directors face a variety of issues in their decision-making, some or all of which may affect property rights of plaintiffs, members, and owners, the extent of the harm that may befall them is significant as they remain in office. The fact that plaintiffs have alleged evidence that some defendants unlawfully voted upon the clubhouse construction project, even though it was plainly a decision that was required to be put to a membership vote, illustrates the type of harm that exists to all. In another instance of unlawful board action, in or about February 2025, defendants assessed a $50 fee upon all owners and members of the association purportedly for defendants' representation of all owners and members in this instant action. The assessment of fee for such legal fees is and now was not authorized by the governing documents of the association to include the Master Declaration and Articles of Incorporation attached hereto, but was also an attempt to paint plaintiffs unfavorably as the literature that accompanied the notice of assessment contained false and defamatory statements about the plaintiffs and those who opposed the bylaw amendments at issue here. Oh my God. Damages individually and derivatively on behalf of the association, all of which were proximately caused by defendants' breaches of fiduciary and or contractual duties, include inter alia and unlawful bylaws that purport to deprive them of the ability to remove a director, an important right that is integral to ensuring that the association is properly governed and not subject to harm by a director who should not be in office, whether for malfeasance, nonfeasance, or otherwise. A sitting board of directors that includes those who were removed by vote and or their replacements in 2024, and damages relative to the construction project and ongoing debt and expense for maintenance, repairs, staffing, insurance, and other costs and liabilities with little offsetting benefit use and unlawful assessments imposed by the board, the $50 for legal expenses, and other damages to be determined in the course of discovery. First claim for relief, unlawful and ultra vires corporate acts, injunctions. So this is where we get to the claims for relief. We are on page 33 of 49. Plaintiffs hereby reallege and incorporate herein by reference which all the allegations set forth in paragraphs both above and below as if fully set forth herein. Under North Carolina General Statute, Section 55A-3-04B, a corporation's power to act may be challenged either 1, in a proceeding by a member against the corporation to enjoin the act, or 2, in a proceeding by the corporation, whether directly or derivatively, against an incumbent or former director, officer, or agent of the corporation. As set forth above, the board of directors of the association failed to follow the proper procedure set forth in the bylaws, and it violated applicable provisions of chapters 55A and 47F of the North Carolina General Statutes in seeking to amend the bylaws. In addition, the board of directors' actions were invalid for failing to provide proper notice to board of directors regarding the vote, which was not waived. No notice of this proposed amendment to the bylaws was provided in advance of the meeting of June 28, 2024, and the item was not listed on the agenda. Plaintiffs have been injured in that the majority vote to remove 4 directors in September 2024 was deemed to have failed because the vote for removal did not reach a supermajority of 67%. Further, plaintiffs have been injured and are suffering an ongoing injury in that contractual provisions of the bylaws were changed unlawfully and to their detriment, requiring them to meet a higher voting requirement in the event that they wish to remove a director. Directors who were validly removed by the majority vote remain in office and continue to make decisions, including but not limited to the unlawful decision to impose a $50 assessment for legal fees. Furthermore, Resolution 25-09, amending the bylaws, does not correct the illegality, and the bylaw remains unlawful to date. The purported amendment of the bylaws altered the requirements for participation in the governance and affairs of the association applicable to the members of the association. A permanent mandatory injunction should be entered requiring defendants to announce to the members that 1. The board vote held to amend the bylaws on June 28, 2024 and or on December 3rd, 2025 was unlawful, ultra vires, and void ab initio. The purported amendments of the bylaws was improper, unlawful, ultra vires, and void ab initio. And 2020 bylaws still apply to the operation and governance of the association with full force and effect. And the majority vote to remove the 4 directors in September 2024 passed. The injunction should also contain such provisions as are necessary to remove or cancel the unlawful ultra vires amendments to the bylaws of record with the Register of Deeds and Secretary of State, restore the 2020 bylaws, and order enforcement of the 2020 version of the bylaws, particularly with respect to director removal provision. The injunction should further require that all purported acts taken by the board of directors or the association pursuant to purported authority contained in the ultra vires amended bylaws to include the board's determination that the 52.3% vote to remove 4 directors or any of their replacements for the remaining portions of their term without cause in September 24 did not pass, be declared null and void for lack of authority, that said directors so voted for removal be immediately removed as such vote did not in fact pass under the majority requirement in the proper bylaws, and that any purported actions, decisions, and or votes by any of the 4 directors or replacements that were voted for removal are null and void for lack of authority. This injunction is necessary to restore the status quo, which was in effect prior to June 28, 2024, and to prevent further and ongoing harm to plaintiffs. Plaintiffs have demonstrated a reasonable likelihood that they will prevail on the merits of their case and that irreparable harm will occur if any injunction is not granted. There exists a reasonable apprehension of irreparable loss to plaintiffs with respect to the fact that the directors they voted to remove in September 2024 have not been removed according to their majority vote, and an injunction is reasonably necessary to protect the rights of plaintiffs. There exists a reasonable apprehension of irreparable loss to plaintiffs with respect to their ability to remove directors and may not be acting in the best interest of the association and for which other cause may exist for their removal, and an injunction is reasonably necessary to protect the rights of plaintiffs. Moreover, the removed directors cannot be allowed to purport to act as board members for the corporation when in fact they have no such authority to do so. Proper replacements must be put in place pursuant to the applicable laws and governing documents. The corporation cannot be allowed to be run by those without legal authority to do so. Plaintiffs move pursuant to Rule 65 of the North Carolina Rules of Civil Procedure and North Carolina General Statute Section 55A-3-04 that this court, after the giving of due notice and an opportunity to be heard to the defendants, enter an injunction as outlined above. Plaintiffs further request that any preliminary injunction be converted to a permanent injunction upon final determination in favor of plaintiffs in this matter. Fairfield Harbour is a planned community under North Carolina General Statute Section 47F, created in the state before January 1st, 1999, and then accordingly Section 47F-3-120 declaration limits on attorney's fees applies. North Carolina General Statute 47F-1-102. Plaintiffs seek an award of damages in excess of $25,000, as well as an award of attorney's fees under North Carolina General Sections 55A-3-04, 55A-7-40, 47F-3-120, and or otherwise permitted by law. The second claim for relief, declaratory judgment action. Plaintiffs hereby reallege and incorporate herein by reference each of the allegations set forth in the paragraphs above and below as if fully set forth herein. Plaintiffs bring this declaratory judgment action pursuant to the Uniform Declaratory Judgment Act set forth in North Carolina General Statute Section 1-253 and under the provisions of Section 1, Article 26 of the North Carolina General Statutes, and for the purposes of obtaining from the court a judgment and declaration with respect to the validity of certain acts of the Board of Directors in light of the language contained in the bylaws of Fairfield Harbour, as well as the mandates of Chapters 55A and 47F of the North Carolina General Statutes. Plaintiffs have joined in this action all ascertainable parties who may be affected by the declaration. Upon information and belief, there exists no other parties who are necessary to conduct this action. And then they add another case for reference of non-party owners and declarants are at best proper parties who may attempt to intervene if they so choose. An actual justiciable controversy exists, and thus relief in the form of a declaratory judgment is proper. Plaintiffs contend, and the Board of Directors of the Association unlawfully purported to amend the bylaws by the board vote of June 28, 2024. Plaintiffs further contend that the Board of Directors failed to comply with the language of the bylaws and violated applicable provisions of Chapter 55A and 47F in their purported amendment of the bylaws. Plaintiffs further contend that the Board of Directors failed to provide legally sufficient notice of this motion and vote with respect to content and timing. The purported amendment of this bylaw by defendants on December 3rd, 2025 is similarly unlawful due to its supermajority threshold standard. Upon information and belief, the Board of Directors of the Association failed to properly amend the bylaws in other ways which will be proven at trial. Plaintiffs contend that the purported amendments reflected by are ultra vires acts of the association and are therefore void ab initio. Upon information and belief, the Board of Directors contends that all amendments to the bylaws were proper and that all actions taken thereto are valid and lawful. Plaintiffs have been damaged by the acts of the Board of Directors of the Association in purportedly amending the bylaws of the association without proper authority and in violation of North Carolina law. Pursuant to North Carolina General Statute Section 1-254, plaintiffs request that this court invoke its jurisdiction under the Declaratory Judgment Act to construe the bylaws of the Fairfield Harbour Property Owners Association, Inc., as well as provisions of Chapters 55A and 47F relating to amendment in order to determine the validity of the purported amendment, the sufficiency of the notice, and the validity of all subsequent actions taken pursuant to the purported authority contained in Exhibit 6, and specifically its failure to remove the 4 directors, Pendleton, Albertini, Brody, and Pfeffercorn, and or their replacements, in this case, Debbie Harris replaced Gail Albertini, and Larry Basin replaced David Pfeffercorn, now deceased. That is a majority of the association voted to remove in September 2024. Plaintiffs further request that the court issue a declaratory judgment declaring the amendment to the bylaws both on June 28, 2024 and December 3rd, 2025, requiring a supermajority vote to be void ab initio and striking it from the record, and further reversing or declaring null and void all subsequent actions taken pursuant to the purported amendments to the bylaws, and declare that the majority vote for removal of the 4 members of the Board of Directors on or about September 24th, 2024 was sufficient for their removal, and that as of September 24th, 2024, said 4 directors were removed as board members. Plaintiffs further request that the court issue a declaratory judgment that the 2025 $50 assessment by defendants, the board for legal fees, to defendant all to defend all owners members in the instant litigation is and was unlawful and invalid, and order reimbursement of said funds. In the event that such a declaratory judgment is entered, plaintiffs pray into this court pursuant to North Carolina General Statute Section 1-259 for such supplemental relief as is necessary to put the declaration into effect, including but not limited to striking and canceling the amended bylaws and resolutions of record, and restoring the previous bylaws that were in effect prior to June 28, 2024, and or reimbursing the $50 assessment fee paid by any owners or members. Fairfield Harbour is a planned community under North Carolina General Statute Section 47F, created in the state before January 1st, 1999, and accordingly Section 47F-3-120 declaration limits on attorney's fees applies. Pursuant authority contained in North Carolina General Statute Section 55A-3-04, 55A-7-40, and or 47F-3-120s, plaintiffs request reimbursement for all attorney's fees spent in order to obtain this declaration, injunction, and supplemental relief. The third claim for relief, so we're at number 3, what they're requesting: breach of fiduciary duty. Plaintiffs hereby reallege and incorporate herein by reference each of the allegations set forth in the paragraphs above and below as if fully set forth herein. The officers and board members of the association owe a statutorily imposed fiduciary duty to the association. North Carolina General Statute 55A-8-30. All defendants owed a fiduciary duty to Fairfield Harbour Property Owners Association. All defendants also were in a special, personal, de facto fiduciary relationship with plaintiffs and the association, because a fiduciary relationship can arise in a variety of circumstances and may stem from varied and unpredictable facts. It gives another case to reference. Defendants breached their fiduciary duty to plaintiffs and the association, which directly caused damages as set forth above and below. The board owes its duties to the association and all of its members. Plaintiffs and members of the association reposed confidence in defendants, resulting in defendants' superiority and influence over them, including defendants' holding of all the cards. In this case, the relationship arose because defendants, in concert with one another and with their attorney, not only announced but acted on repeated false claims that the membership had no right to vote on matters such as the clubhouse construction project, and continued this course of action with similar claims as to the bylaw amendment. ECF 29, page 13. Give me one second. Defendant state. Defendant association's bylaws explicitly authorize bylaw amendments by a vote of 5 of 7 directors of defendant association. And ECF 29.1 in Exhibit 1, Hope Carmichael Affidavit 26, there is no provision in defendants associations governing documents that entitles members to vote on bylaw amendments. Instead, the bylaws vest amendment authority solely to defendant associations board of directors, and no statutory provision overrides this governance structure. A fiduciary duty arose between defendants and plaintiffs and or association because A, confidence was reposed in defendants and their counsel due to said defendant counsel's assurances that they, and not the membership, were authorized to take action at issue, including the clubhouse construction project, and that members lacked a right to vote. B, deceitful or minimally errant representations were made regarding the consent, meaning, and definition of the law and the governing documents to which justifying the Harbor Club was not subject to a membership vote, and a capital expenditure because of the cost of the multi-million-dollar construction project was to be repaid over time as a loan, hence creating a figure much smaller than the $6 million plus figure for the entire cost that would necessarily require a membership vote. All defendants were and are in position of superiority and influence, as well as dominance and control, with the intent to disenfranchise plaintiffs and the association, including through their acts of actively informing members, owners, that they had no right to vote on the clubhouse construction project, and also by entrenching themselves in their position with the bylaw amendments. Defendants held all the cards and that they made closed-door decisions outside the presence of membership, one example being the failure to advise the owners or members in the June 26th meeting that they were planning on amending the bylaws regarding the director removal, and utilize association counsel's statements that the board was permitted to make said decisions regarding the clubhouse construction project and the bylaw change. Defendants hold all the cards because they have actively and expressly refused the members' right to vote on certain matters, and even when members attempted to vote, such as the September 2024 recall, defendants refused to recognize the result, resting upon their unlawful affected supermajority requirement. Defendant board members did and continue to take advantage of their positions as board members to entrench themselves in office by refusing to correct the unlawful bylaw to require only a majority, not a supermajority, for removal as the law and bylaws require. Defendants have further unlawfully exercised control over plaintiffs and associations members by unlawfully imposing, despite no governing document that allows it, a $50 assessment in the early 2025 that was purported to cover legal expenses of defending this litigation. Plaintiffs and the association relied upon the false and incorrect statement of the association's attorney made public on June 26, 2024, and other times, that the membership was not entitled to vote upon the decision of moving forward with the Harbor Club construction project. Defendants continued to intentionally mislead and to make false representations to the association and plaintiffs, including the statement that the Board of Directors 12/3/2025 in Exhibit 10, in which they falsely suggested that their action that is fully within the board's discretion to determine the voting percentage threshold required to remove a director. Defendants, through and by the appearance of legal authority as expressed by the association's counsel, created a fiduciary relationship between the defendants and plaintiffs and the association, in that defendants and the superior party asserted and exerted authority by instructing the inferior party that they had no right to vote upon the clubhouse construction project, and thereafter instructing the inferior party that it had no right to vote on the matter of the bylaw change, even after the issue was raised by opposing board members and other dates in 2025. Defendants exerted control and authority over members, plaintiffs, specifically for their own gain and interest, and to the detriment of members, plaintiffs, association. In addition, the defendants were inattentive, acted unreasonably, and in bad faith, and were not loyal to the association by engaging in the acts set forth above and herein. Defendants breached their fiduciary duty to plaintiffs and the association by inter alia, voting for and otherwise approving a bylaw amendment that entrenched directors in their position and made it unlawfully difficult and or practically impossibility to remove a director, no matter the reason. Failing to correct the illegal bylaw upon receiving information that the bylaw amendment was invalid, illegal, which occurred on many occasions, including but not limited to the derivative demand letter of October 2024, the filed complaint, amended complaint, and expert report disclosure from Thomas Judson, and other demands conveyed through their parties and councils in 2025. Usurping the association's members' right to vote upon the clubhouse construction project, even though defendants were made aware of the members' desire to have the matter put to a membership vote in June of 2024 and at other times, depriving the members of this vote, notwithstanding the fact that the construction project constituted a capital expenditure, which, according to the Defendants Association governing documents, required membership vote for approval. Imposing a $50 assessment on all owners' members in 2025 for purported legal fees in defense of this action, which stems from defendants' self-serving efforts to entrench themselves in their positions as directors. Other ways to be proven at trial. In addition, defendants' actions were part of a scheme by defendants to control all decision-making and further own their personal interests and or convenience at the expense of the plaintiffs and the association, and causing damages as set forth above and which are also ongoing. Defendants' conduct while acting in a position of trust was extreme, outrageous, and with conscious disregard for the rights of the association and its owners and members, entitling them to punitive damages under North Carolina General Statute 1-D1. As a direct and proximate result of defendants' actions and inactions, the plaintiff and association have suffered monetary and other damages in excess of the jurisdictional threshold of $25,000. Fourth claim for relief. We got 4 more pages left, y'all. We can do this. Fourth claim for relief. Plaintiffs hereby reallege and incorporate herein by reference each of the allegations set forth in the paragraphs both above and below as fully set forth herein. The bylaws and governing documents of the association are a contract by which all parties are bound. By engaging in the conduct set forth above, defendants materially breach their contracts with plaintiffs. These material breaches include amending the bylaws to require a supermajority vote to remove a director, unlawfully amending the bylaws without notice, refusing to restore the bylaw to comply with the law, imposing a $50 assessment for legal fees despite the fact that the governing documents do not allow for such. That's in the master declarations of Exhibit 1, pages 10 and 11. Approving the clubhouse construction project without a membership vote in violation of the bylaws, which required the same for the capital expenditure of this size. Other breaches as may be discovered during the discovery and or trial. As a direct and proximate result of said breaches, plaintiffs and the association were damaged as set forth in the details above. As a direct and proximate result of defendants' actions and inactions, the plaintiffs and association have suffered monetary and other damages in excess of the jurisdictional threshold of $25,000. So here is the jury demand. Plaintiffs hereby demand a jury trial on all issues so trialable. Therefore, plaintiffs respectively pray into the court for the following relief. The plaintiffs recover actual damages of defendants where allowed by law in an amount in excess of $25,000, and that the court determined that the acts of the board have that the court determined that the acts of the board of directors of defendant association in amending the bylaws on or about June 28, 2024 were unlawful, ultra vires, and void ab initio under section 55A-3-04, and issue injunctive relief necessary to restore the status quo in effect prior to the June 28, 2024 vote and amendment, and that the court enjoined defendants from utilizing or applying the unlawful supermajority vote for removal of a director, and require that the statutorily required threshold, a majority of votes cast, be applied in the event of any removal vote, and that the court enjoined defendants from maintaining their purportedly amended bylaw to remain of record or in effect to order any relief to return the bylaw to its wording as it existed in the 2020 bylaws. That the court enter a declaratory judgment finding that the purported amendment of the bylaws, both in 2024 and on December 3rd, 2025, require a supermajority vote for a removal of director are unlawful, invalid, ultra vires, and void ab initio, and any subsequent actions taken pursuant to the purported authority of the amended and restated bylaws, to include the failure to remove the 4 directors that plaintiffs' members voted by majority to remove in September 2024, are and will be void ab initio, and that any purported actions, decisions, and or votes by any of the 4 directors or replacements that were voted for removal are null and void for lack of authority, and are and will be void ab initio, and that the court order the return of all monies paid by any plaintiff or member in the nature of the $50 assessment imposed in 2025 purportedly to fund the defense of this litigation, and that the court enter such supplemental relief as necessary to put the declaration into effect to include removal of directors L. Howard L. Pendleton, Susan Deborah Harris, Robert James Brody II, and Lawrence W. Basin, and or any individuals that may have subsequently replaced them, to strike the amended bylaws and Resolution 2024-03 and Resolution 2025-09, and to restore the previous version of the bylaws of Fairfield Harbour 2020 bylaws Exhibit 4, and that the plaintiffs recover punitive damages and attorney's fees for defendants under North Carolina General Statute Section 55A-3-04, 55A-7-40, and or 47F-3-120, or in the discretion of the court, and the plaintiffs have a trial by jury on all issues so trialable, and that the cost of this action be taxed against the defendants, and for such further and other further relief as the court deems just and proper. And then that was emailed out and filed. Okay. So this was the certificate of service. Okay. And just quickly going through the exhibit. So this first exhibit is our master declarations of Fairfield Harbour. So if you own a property in Fairfield Harbour, these master declarations apply to you and are the underpinning for all bylaws and resolutions that govern our community in concert with the North Carolina general statutes and other applicable law. So I'm not going to read these to you. You should have received these prior to signing your mortgage or anything like that, lease agreement. But if not, you can always find them here. And okay, we keep going. These were also, just so we're aware, these were from 1979. Okay. Then we have Exhibit 2. Exhibit 2 is the Articles of Amendment to the Restated Charter of Fairfield Harbour of the Property Owners Association. Okay. Then we have Exhibit 3 is the Declaration of the Unit Ownership. So that's for the condominiums and words are hard after reading all of that, so forgive me, but that is what that Exhibit 3 is. Exhibit 4 is our amended and restated bylaws, and this is the May 5th, 2020 revision. So you will see that there in full. So again, this kind of sits on top of our master declarations, North Carolina general statutes, and all other applicable laws and provisions. What I want to get to is Exhibit 5. So Exhibit 5, this is that June 28th meeting of the board, where you can see the agenda here did not include notice that there was going to be a motion brought to amend the bylaws. So that is one of the issues brought forth in this claim. Nor is it hold on, this goes through all of the notes as they were approved. Here you will see on this last page of this Exhibit 5, in this first paragraph, where Director Pendleton made a motion to amend the bylaw, again, not in the agenda prior to the beginning of the meeting, and at the very tail end of this meeting prior to its adjournment. Then we have Exhibit 6. Exhibit 6 is the resolution. So this is exactly what, so you'll see in the follow-up notes from that meeting, where Attorney Carmichael said that she would send Secretary Miller the exact wording needed for the amendment. That is this document, Exhibit 6, okay? Where you can see here under Section A, the last sentence is, pursuant to these bylaws shall not be less than 67% of the eligible votes of the POA membership. Again, entrenching our current active sitting board from having any members removed by that supermajority vote. This is the memo to outline the procedures performed by Ernie and accountants. Okay, so this is Exhibit 7. That was who did the vote counting. Jordan Price. So this is the first letter where we talk about the derivative demands after that bylaw change. Okay. And I think we've read these on a prior podcast. If not, let me know. I'm trying to get to what I want to get to that I don't believe I have gone over in detail. This is where we requested the vote. This is the community management expert witness report. And if you've not had a chance to go through this, this is page 114 of the 125-page document of the second amended complaint that was recorded this week on December 17th. But I thought this was really telling. This is Exhibit 9. And the preliminary report, this report is subject to change if additional information is necessary. Sound governance and transparency are the bedrock of a strong community leadership. Additionally, the directors of the board have a fiduciary responsibility to act in the best interest of the community as a whole, cannot be compromised by self-serving actions. Unfortunately, an analysis of the actions taken by the board of directors of Fairfield Harbour demonstrates that many of their actions do not comply with state law and or the governing documents of the community and were not in the best interest of the community. Unauthorized executive sessions. According to the Board of Director minutes dated June 28, 2024, the board went into executive session at 4:47 p.m. and exited the executive session at 5:01 p.m. Upon exiting the executive session, the board immediately took a vote to amend the bylaws. 2 minutes after exiting the executive session, the meeting was adjourned at 5:03. In reviewing the amended and restated bylaws of Fairfield Harbour Property Association, Article 5, Section 5D states, executive sessions are portions of the board meeting where confidential matters are discussed. In accordance with the current Robert's Rules of Order, newly revised, the board may go into executive session when discussing issues that, if publicly discussed, could violate privacy laws or harm and cause embarrassment to the association or another party. Adoption of actions taken in executive session will be recorded in the regular session minutes. Topics that may be discussed in executive session include the following: consulting with the association counsel regarding legal issues, discussing litigation or prospective litigation either by association or against the association, reviewing personal information that is confidential, protected by law, or should not be generally known, such as delinquencies in homeowner association dues assessments, conferring about contracts or property purchases, reviewing association employees or personnel issues, and or reviewing disciplinary matters in violation of policies and regulations by association members. In my experience, again, this is Thomas Judson that wrote this. In my experience, the above section of the bylaws is well written and complies with industry norms. The discussion of the board of directors regarding modifying the bylaws does not fall into any of the approved topics allowed during an executive session. It is clear the board should not have discussed this topic in executive session and should not have voted on this topic that was discussed during an unauthorized executive session. To put things into perspective, at the community I currently manage, the following steps must be taken before a change is made to the bylaws. Month 1, discussion at Rules and Regulations Committee. A detailed agenda is posted on the association's website well in advance. The meeting includes an open forum for members to comment. Meeting minutes are taken, the meeting is live streamed, and the meeting is recorded with the video available on the association's website. Month 1, Board of Directors work session. A detailed agenda is posted to the association's website well in advance. The meeting includes an open forum for member comments. Meeting minutes are taken, and the meeting is live streamed. The meeting is recorded with the video available on the association's website. Month 1, Board of Director regular meeting. A detailed agenda is posted to the association's website well in advance. First of 2 required votes are taken. The meeting includes an open forum for member comments. Meeting minutes are taken, and the meeting is live streamed. The meeting is recorded with the video available on the association's website. Month 2, discussion at Rules and Regulations Committee. A detailed agenda is posted to the association's website well in advance. The meeting includes an open forum for member comments. Meeting minutes are taken, and the meeting is live streamed, and the meeting is recorded with the video available on the association's website. Month 2, Board of Directors working session. A detailed agenda is posted to the association's website well in advance. The meeting includes an open forum for the members' comments. Meeting minutes are taken and the meeting is live streamed. The meeting is recorded with the video available on the association's website. Month 2, Board of Directors regular meeting. A detailed agenda is posted to the association's website well in advance. Second of 2 required votes is taken. The meeting includes an open forum for member comments. Meeting minutes are taken and the meeting is live streamed. The meeting is recorded with the video available on the association's website. Many of the above steps are not required by my community's governing documents. These additional steps are freely taken to ensure the community input and transparency. For the Fairfield Harbour Board to discuss this change to the bylaws in executive session and to vote on the change without giving the community an opportunity to voice their support, or more likely their dissent, is a gross violation of transparency and community trust. If the board intends to make changes to the bylaws, they must adhere to the requirements of their own governing documents. Advance notice requirement was not met. North Carolina General Statute 55A-10-20 states the following: the corporation shall provide at least 5 days written notice of any meeting of directors at which an amendment is to be voted upon. The notice shall state the purpose or one of the purposes of the meeting is to consider a proposed amendment to the bylaws and contain or be accompanied by a copy or summary of the amendment, or state the general nature of the amendment. The amendment shall be approved by a majority of the directors in the office at the time the amendment is adopted. From an industry perspective, the above regulation translates into the following required steps that need to be taken by a board to change its bylaws. Notice must be given 5 days in advance in writing. A detailed agenda must be provided, providing the purpose. A draft copy of the proposed agenda to the bylaws has been written and shared along with the agenda. At my community, for each of the 6 community meetings which are required to change a bylaw, notice of meetings must be given and agendas must be published in advance. Additionally, a draft copy of the proposed changes to the bylaws are provided on the association's website. Unfortunately, the board at Fairfield Harbour did not follow the steps required by state law. The first mention of the change to the bylaws occurred at the meeting on June 28, 2024, not in advance. The quick and hasty actions of the board conjures up images of decisions made in a smoke-filled back room, not of sound governance and transparency. Directors Barajas and Moore voted against the changes, so they clearly did not agree with a waiver of notice. If the board intends to make changes to the bylaws, they must adhere to the requirements of state law. Bylaw changes are not allowed. At the board meeting on June 28, 2024, the board changed the bylaws to adjust the requirement for removing a board member from simple majority to a supermajority. This change contradicts North Carolina General Statute Section 55A-8-0H, which states the following: a director may be removed under subsection A or B of this section only if the number of votes cast to remove the director would be sufficient to elect the director at a meeting to elect directors. For Fairfield Harbour, a director can be elected through a simple majority, or if there are several candidates, they can be elected through a plurality. Thus, a candidate can be elected by getting just over 50% or by lesser percentage if there are several candidates, provided there are candidate with the highest percentage of votes. In looking at the requirement to get elected at Fairfield Harbour, a simple majority is always enough to get elected. As a result, this should be the benchmark to judge the requirement amount to be sufficient to elect the director. By setting a standard for a supermajority to remove a board member, the board has created an unreasonably high threshold that conflicts with state law. The unreasonably high threshold to remove a board member is made even more challenging by a subtle change to the wording in the bylaws, where previously the results of the vote would be based upon those members who participated in the vote. The new bylaw is based on POA memberships who are eligible to vote. Again, keep in mind that that was changed, in October? There's so many months in this year. But this fall, I think it was December 3rd, at that meeting, Hope Carmichael was there. Don't quote me on the date, but Hope Carmichael was there, and they read a pre-written statement and made changes to the bylaw the same way they did this one. It was the only thing on the agenda. So it's now based on the supermajority 67% of the votes cast. So this was prior to that change. Okay. Okay. Since it's nearly impossible to get every member to participate in a vote, the supermajority requirement is effectively a supermajority, a supermajority designed to make it virtually impossible for the community to ever remove a board member by preventing a board member from ever being removed. This creates a condition of ongoing irreparable harm to the membership. Given the removal of 2 board members occurred only a few months before the changes to the bylaws, it's evidence that the sole purpose of this change to the bylaws was self-interest of the board, not of the community as a whole. The community deserves the right to choose their board members, but these self-serving actions have deprived them of that right. He goes through voting requirements for amendments to the bylaws, stating Section 55A-7-23B states the following: an amendment to the Articles of Incorporation or bylaws on which members are entitled to vote, the purpose of which is to increase or decrease the vote requirement for any member action, shall be approved by the members entitled to vote on that action by vote that would be sufficient to take that action before the amendment. In other words, since the act of removing a board member requires a vote of membership, the homeowners, only the membership has the right to increase or decrease the vote requirement. The actions of the board to increase the vote requirement to a supermajority conflicts with Section 55A-7-23B. If the board is intent on changing the bylaws as they would like, they can appeal to the membership, the homeowners, to encourage them to approve the change. In conclusion, it is within the authority of the board to make reasonable changes to the bylaws, provided the change comply with state law and the community's governing documents. To follow industry norms, the board should take much more community-minded and transparent approach when making changes to the bylaws. Unfortunately, the board's actions to change the bylaws did not follow state law, did not follow the community's governing documents, and were not community-minded and lacked transparency. An individual's home is typically their single most important financial asset. The action of the board have deprived the homeowners of sound governance and have jeopardized the health and well-being of the community, which has led to irreparable harm. A majority of the community has clearly stated that the new board leadership is needed and wanted, yet the board has acted with allegiance to themselves first and not to the community that they are in office to serve. Facts or data considered, and he goes through all of the things that he used to inform his professional opinion. And then we have Exhibit 10. Exhibit 10 is that that resolution to the bylaws that required the supermajority vote, resolution 2025. I'm sorry, this was the one, September 2025. We amended the bylaws. Bylaws shall now be not less than 60 of votes cast by any duly constituted meeting via written ballot. And then there was a statement from the board of directors with that. Let me see if I can make this smaller so I can see it. Hold, please. The board statement regarding today's bylaw change amendment at the meeting held this morning is below, and the resolution is attached to this bulletin. The board has offered multiple times to amend the bylaws in an effort to settle and end the current litigation, both in discussions with the POA's attorney and Mr. Collins, and directly in a very lengthy mediation. While the 5 directors are not in complete agreement on whether this is better for the POA to have higher or lower bar for membership removal of directors, the 5 of us unanimously agree that it is in the best interest of the POA for this divisive litigation to come to an end. Unfortunately, the plaintiffs have not agreed to those offers of compromise. I'm like fighting the urge to come out of my skin. Even without the plaintiff's agreements to dismiss the lawsuit, the board believes it is the right thing to do to put this amendment in place and the document to offer our compromise. That's why I have made the motion and I called the question. In simple terms, what this means is instead of requiring 67% of all eligible votes to remove a director, now the bylaws require 67% of the votes cast at a much lower number. And that is, I think that is the last page of this. Okay, so God, we've been here like an hour and 45 minutes. The reason why the plaintiffs and other members of the community, because I want to be clear that, let me take a sip. The plaintiffs here put their money where their mouth was. They believe that they have been harmed and wanted to seek litigation, not only in support of themselves, but also in making our community stronger and better, which applause. Again, I've said this on multiple live streams. Kudos to these plaintiffs, okay? But I don't want the community and those that watch this that own properties in our community but don't live there full time but do watch my channel. There is a huge community backing these plaintiffs. We agree. There is a collective group of us that agree that the supermajority vote requirement, the lack of transparency, the not allowing the membership to vote on the community is harmful to our community. We do not put people into a form of power on our small area. Like, this is where we want to live. We want to be neighbors. We want to be governed by a group of people that believe in our collective best interest, and that is not happening today. The reason why the plaintiffs do not agree with these compromises is because the compromises are still at conflict with the law and with other parts within our governing documents. There are conflicts within the documents themselves. There are conflicts with the compromised bylaw change and state law. And so we are taking it further. These plaintiffs are taking it further, asking for a jury trial, asking for a judge to hear what is happening and allow a jury of our peers, people in North Carolina, to be able to tell us whether or not we can go back to the way that things were, kind of regroup, create some cohesion within our community, heal some very deep wounds within our community, and begin to move forward transparently and collectively in a singular direction. We have been so divisive much longer. I mean, we moved in 2021, and there was already this kind of undercurrent of dissension when we moved in. Like I said, the very first thing I think we got to asked about was this community center, put in priority order, like what you want to have in this community center, and to see it actually live in person and not include the things that were voted on in that is mind-boggling. But the reason why this is not good enough is because it's not good enough. Okay? So for those that were unable to just sit and go through 125 pages of the second amended complaint that was filed electronically with our Craven County Superior Court on December 17th, 2025. I hope you can listen to this while you're running errands or going to bed or doing anything else, and it gives you some context into the multiple issues at hand here and what the plaintiffs in this litigation are requesting. And the one amendment where they unlawfully requested $50 to aid the community in fighting this litigation, they are requesting that back, not just on behalf of the plaintiffs, but on behalf of our entire community. Our entire community should get that $50 back if you paid it last year. So I just think that it behooves us all to stay engaged in this, to understand what is on the table, what is at stake, and to make a choice. How are we going to move forward as a community, and to make sure that our voice is heard? If you cannot go to the meetings, which I cannot right now, the board meetings in person, listen into the recordings, read the bulletins, read the emails that come out on Friday. I mean, they're so important, not only about the classes and the parades and things like that are happening, but take time to read the board minutes whenever they're published, to be a part of the meetings that we're allowed to be a part of and understand what is happening within this microcosm of North Carolina, because it's important. It also sets precedent for other communities. There are multiple Facebook groups across the country where POAs are acting rogue or homeowners associations are acting rogue, making rules and regulations that do not adhere to their bylaws. We are just one of them, right? But people are going to start looking for case precedent to be able to act upon. And we have the chance to start to fund and send a movement to change all of this regulation, which, if you hadn't heard yet, Hope Carmichael is one of the premier authorities that helps to write legislation that governs how POAs and HOAs operate. And that is who our POA has hired to help support this litigation. She stays on staff with us. So the fact that in this, I had to physically restrain myself from stopping and saying, but the fact that we would pay Hope Carmichael to give us her opinion versus using that money to put towards a community vote to understand what everyone's opinion is that actually lives here. Mind-boggling to me. Mind-boggling to me. But thank you so much for listening. Please stay, keep a pulse on what's happening in our community. It's so important. And I hope you have a great rest of your weekend. And if I don't talk to you again, I hope you have a very Merry Christmas. Okay? Bye, guys. Have a good rest of your day.